counsel. Good morning.
Good morning, Your Honor. Maura O'Keefe for Appellant, City of Newton. The city has appealed the decision of the Superior Court to deny its motion for summary judgment, which was premised in the city's immunity from suit under the recreational use statute. The recreational use statute states that a landowner who permits the public to use its land without imposing a fee, therefore, shall not be liable for personal injury absent willful,
Well,
wanton.
was a fee paid in this case?
The applicable inquiry is whether a particular plaintiff paid a fee to the city for use of the land. Here, the plaintiff, Mr. Marcus, did not pay a fee to the city for use of the land.
If the city Parks and Recreation Department, if it has one, had operated a softball league and charged the people who were in the softball league a fee to pay on the city parks, would that be different? Would you be arguing the same?
I would need to know more facts for that, but for the facts here, the city did charge the fee to the league, but that money was used to defray the cost of maintenance. It was used to seed, to aerate the field, to draw lines on the field, for example.
But just to take Justice Spina's question, if instead of the league, these individual players, the $1,200 was made up by 10 or I don't know how many people, but anyway, enough people to make up $1,200, but they paid it individually. And even though the money was used for just the reasons, would that be a fee?
Are you saying that if the plaintiff paid the fee directly to the city?
Correct.
It's possible. However, then the question would really be whether it would be for the exclusive use of the field.
Well, the thing is, you're really relying on a few cases because the statute doesn't define fee.
No, it does not.
It says the liability of any person, and that would include Newton, who imposes a charge or fee for the use of his land by the public, and so it goes on. That's all the statute says.
That's
so
correct.
The cases have basically emerged from particular factual circumstances. But, it seems to me that it may be a mistake to draw more general rules from what have been pretty fact-specific kinds of circumstances.
That's correct, and all the city has to go on is so far how the courts have interpreted it. And what it all comes back to, again, is the inquiry that has to be applied for the recreational use statute, and that is whether a particular plaintiff paid a fee for the use of the land, and that is simply not what we have here.
But those persons were spectators. They were not participants.
But there isn't a distinction in the case law between spectators
Well,
and...
isn't there? I mean, if I were to have gone to that field with my softball team and been playing on that field, I would have been kicked off, would I have not? Because they had paid for the right to use that field at that time.
No, the city would not kick anyone off the field if they came down to play. The city is open and freely open to the public.
So what does it mean to reserve a field if it means that somebody who has not reserved the field can't be kicked off?
Truly, it's a convenience, and the city does not police it. We do not send someone down there. We do not administrate it. It is for the convenience of the league. And really, what it is, it's not a fee for use. And if you look at the particular facts in this case...
So they're paying for no good reason? They're paying even though it gets them nothing?
It gets them a convenience to be able to determine who is playing at what particular time. This field, McGrath Field, is 10.5 acres. There are two softball fields. There are 2 soccer fields and 7 tennis courts.
But during the summer, is this the only organization that paid money to the city to reserve the field?
I don't have an answer for that. I do not know.
Is this part of the record, what the facts are regarding the terms and conditions of use of the softball field? And you say it's just the convenience. The plaintiff says the team wouldn't be permitted to play the game had they not paid a fee to the city, which entitled them to reserve the use of the field on the date of the injuries.
Yes.
And so you have a dispute as to what the terms and conditions of the use of the field are, it seems to me.
The city has submitted an affidavit by Tom Cahill, who is a manager for the Parks and Recreation Department for the city. And in that affidavit, Mr. Cahill states that the money that was received from the league, not from the plaintiff, was used to defray costs of maintenance. It was also used to reserve certain time slots throughout the summer. And in the affidavit, Mr. Cahill outlines to the penny what the money was spent for, and it was spent solely for maintenance. He also states in that affidavit that the field, that no admission charge was ever paid for anyone to enter the field.
Are you
Why does it matter whether or not it's paid for maintenance or something else? I mean, if you were to charge $2 for every person to enter that field, what difference would it make as to what the money then gets spent for?
Well, Dunn v. City of Boston did seem to make that sort of distinction, where it said that money that the City of Boston received went towards janitorial services or to maintaining.
So that means that a superior court trying to decide this issue is then going to have to follow the money and sort out what the money is used for? Isn't that sort of a bizarre way to determine?
Well, I'm not sure that I would characterize it as a bizarre way to determine it. However, that is what the case law says.
One case.
Psych v. Town of Canton
But
also.
aren't those, I mean, those are different in the sense that the money, just to take the Dunn case, the money was used for services that related specifically to the use that Dunn's employer was making of the land. In other words, janitorial services, at least as I took it, janitorial services that related to the, I forget what it was called, but it was some organization was having an event in City Hall Plaza, right?
Yes. Likewise here, the money that the city receives is used to maintain the field so that people may use it.
Yeah, but it isn't specifically for this league. It isn't like the league had an event and it was a picnic, and so the money was used for janitorial service to clean up after the picnic. It's not like that. It's a much more general use of this money to maintain the fields for whomever might use it, including this league.
Including this league.
Right.
It is not exclusively for the benefit of the league.
But if there's nothing in the record to indicate, I mean, I'm trying to figure out, was this a voluntary payment on the part of the league? Could they reserve the spot without having made the payment?
No, the important issue is whether they could use the field without payment, and they certainly could have. That is what the statute requires.
But they would take their chances, right?
That's correct.
And you don't say that if Justice Gantz's team comes at 2 o'clock on this, whatever afternoon this is, or 7 o'clock at night, that the league couldn't say, sorry, we've got this reserved, you've got to find somewhere else? They would have to duke it out?
That someplace else could certainly be still on McGrath Field.
Well, it could be, but what if somebody else has paid $1,200 to reserve the other field?
Again, the city doesn't police this, and it is a convenience fee, but this all goes back to the language of the statute and also the interpreting case law that it says whether it's a particular plaintiff. And I reiterate that Mr. Marcus, the plaintiff here, paid nothing to the city for the use of the field. The city has a secondary argument here, and this is assuming that the recreational use statute applies, that claims of negligence are not permitted under the recreational use statute, that the plaintiff would have to show that there was some willful, wanton, or reckless conduct on the part of the city in order to take away the protections of the recreational use statute. There simply is nothing in the record that would amount to willful, wanton, or reckless conduct, and this is the other reason why the city is entitled to summary judgment in its favor.
But doesn't that go to whether or not the present execution doctrine should apply? Is because you need a summary judgment record at the very least for that to be determined?
That's correct, and it is the city's contention that the present execution doctrine does apply in this instance.
I know it is, but isn't it generally applied with regard to a motion to dismiss and not with respect to summary judgment? I mean,
there's not a hard and fast rule as such. It actually is applied, supposed to be applied at the earliest possible time in litigation, and I have several examples of when the present execution doctrine was applied at the summary judgment stage. For example, Dunn v. City of Boston. The City of Boston lost its motion for summary judgment and brought an appeal claiming present execution doctrine. Also, just 6 months ago, this court decided the case of Maxwell v. AIG domestic claims, in which AIG brought a summary judgment motion in the Superior Court, which was denied, and this court allowed AIG to use the present execution doctrine to appeal.
Wasn't there something in the language of the statute about immunity?
Yes, that's correct. Are you talking about in the Maxwell case? Yes, and that is another reason why I believe the city is entitled to.
It doesn't say immune from suit.
No,
so
it
shall
says-
not be liable. That's
That's
different.
correct.
That's
It
very
says-
different.
It is, well, there's an overlap in Massachusetts, however, and it's a type of qualified immunity. In the Maxwell case, the statute in question stated that the insurance company will be immune from liability. However, this court interpreted that if certain facts could be established, that immunity from liability was a de facto immunity from suit and allowed the appeal to continue. And that is exactly what the city is asking for this court to determine in this issue, where the recreational use statute specifically states that there shall be an immunity from liability. However, if it can be determined that the plaintiff cannot establish any case of willful, wanton, or reckless conduct, that equates to a de facto immunity from suit, and therefore the city is entitled to immediate appeal.
But there's the question of the fee, nonetheless.
There is the question of the fee.
And so you also have to establish that there was no fee charged or received. So there's more than the wanton and reckless issue.
There is,
And the fee issue seems to be one about which there is some dispute.
there is.
And so there's no entitlement to the immunity, as you're claiming under the statute, until you can establish the preconditions for it.
Well, there's no factual dispute as to the fee. The parties agree that Mr. Marcus paid $80 to be a member of his league. And in return for the $80, he was entitled to membership in the league. It also gave him a team shirt. It also allowed him to attend the cookout at the end of the season. And there is also no dispute that the league itself paid $1,200 to the city to reserve certain time slots. And in return, it got the convenience of having those time slots. And it also got in return that the field would be maintained in
Let
a
me
certain...
put the question a different way, which is that if we were to decide as a matter of law on this record that that was a fee, then your argument about immunity goes.
If this court is to determine that the fee that plaintiff paid to the league somehow falls underneath the recreational use statute as a fee paid to the city for use of the field, then the city would lose its recreational use statute argument in its entirety. However, that is simply not the case here, because I go back to what's stated in the Woolley case, where the proper inquiry under this statute is that you have to ask whether a particular plaintiff, here Mr. Marcus, paid to the landowner, which is the city, a use fee that in return for giving the money, the city allowed him to enter the field. McGrath Field is open freely and open to the public 24 hours a day, 7 days a week, 365 days a year. There is no admission fee. There is no entrance fee. There is no parking fee.
So if the city wanted to impose a fee on dog walkers, because they sometimes create maintenance problems, could it do that? Well, you would, if they had to pay a $2 fee to walk their dog, well, they would have to pay that directly to the city. But it was for maintenance of the dog area. That wouldn't come under the fee?
It would, and the
It would be a
facts-
fee. It would be a fee.
it
Even though
would
they
be
could
fee.
use it without a dog. If they want to bring the dog, they got to pay a fee.
It would, and the difference is that the dog walkers would pay the fee directly to the city. And
That's the difference. Well, there's two
Yes.
issues here. One, is this paid to the city? And two, was it really a fee? You're saying it wasn't paid to the city and it wasn't a fee.
I'm not saying that it's not a fee. I'm saying that it wasn't for use of the land, that the plaintiff could have used the land at any time along with every other single member of the public. And that is what the issue is. It's not that it wasn't a fee, but Mr. Marcus didn't pay his money to the city. We received money.
So the dog walker case, you would argue, well, you can walk anywhere, anytime you want, but if you want to bring a dog, that's different.
It would be different because the dog walker, one, paid the money directly to the city, and two, paid the money to use particular closed-off portions of land to walk the dog. So there are two differentiations there.
Okay, as opposed to a baseball diamond.
Well, as opposed to the fact that the baseball diamond is free and open to anyone at any
And I
time.
assume the dog walking area would be free and open to anyone if they didn't bring a dog, in any event. Okay. I won't push the...
Okay, thank you.
Back on your present execution, of course, Dunn, the judgment was in favor of the city. That's what was appealed. It was a final judgment, wasn't it?
My understanding was that the city had lost its motion for, now that I'm thinking about it, I'm sorry, I can't, I believed that it was the same factual set of circumstances as we're looking at here, but the Maxwell case is exactly what we're talking about. And I see that I am out of time, and so I respectfully request that this honorable court reverse the decision of the Superior Court and enter judgment in the city's favor. Thank you.
Thank you.
Good morning, Your Honors. If it pleases the court, Joan Amon for the plaintiff Edward Marcus. The court asked the parties to answer one specific question, and that was whether the recreational use statute provides an immunity from suit. It does not. It does not because the fee is paid. The recreational use statute, in fact, does just the opposite. It spells out when a claim may be made. A claim may be made when a fee is paid. A claim may be made when there's willful, wanton, and reckless misconduct.
So if you had a case which didn't have a fee, are you saying, I'm just trying to understand the scope of what you're saying it doesn't do. Is it that it doesn't provide immunity because in this case a fee was paid, or the statute just doesn't for anybody provide immunity?
I'm saying that claims may be made if fees are paid or if there is reckless, wanton, and willful misconduct.
And if, as in this case, the city challenges whether it is a fee or not, does that become a question of present execution because maybe the trial judge was, the motion judge was wrong? I'm just trying to figure out if you're thinking that, yes, it's immunity, except it isn't if you've got a fee, and it isn't if you've got willful, wanton, and reckless, or are you saying it isn't immunity ever? It's that freedom from liability isn't immunity from suit.
In this particular statute, there is no immunity from suit. And because of the title of the statute itself, it's called Landowners Liability Limited, and it's very similar to a charitable immunity statute, which is called Charitable Organizations Limitations on Tort Liability.
Okay.
There is no immunity from suit under either one. There are only limitations.
Well, in this situation, is it your position that a fee was paid to the city?
Yes, that is correct, Your Honor. Mr. Marcus paid a fee to the Jewish co-ed softball team. The Jewish co-ed softball team, in turn, paid a fee to the city of Newton. That fee reserved that field for their exclusive use every Sunday afternoon, and that is in the record. Nobody else was able to use that fee. And in fact, the fee was called a permitting fee by the city of Newton. Had Mr. Marcus not paid the softball league, he would not have been allowed on the field.
Who would have prevented him from using that baseball field?
The Jewish co-ed softball league would know that he was not a member and not allowed on that field. And the league...
So they acted as agents for the city?
No, the league patrolled its own players. If you don't pay us, you don't play, you're not on the field. The league itself would not have been allowed on the field because the fee they paid has been characterized by the city of Newton as a permitting fee.
Who would have kept the league from using the field if they had not paid?
The city of Newton Recreation Department.
Is it the case that, at least as I understood what Mr. Keefe was saying, if nobody else had reserved the field, the league could have come on to the field at 2 o'clock on Sunday afternoon? So is it the case that the league couldn't have done that only if someone else had reserved it?
Right, the fee paid was for permitting and reservation. And because they had formal tournaments and formal play, they wanted a field
But if,
every Sunday.
but if 6 or 7 people showed up and wanted to play softball, and nobody was using the field, those 6 or 7 people, at least I understand from your sister's argument, those 6 or 7 people could have played on that field.
Oh, sure. If nobody else had reserved it, anybody could go and play on that field. But the fact was that this league was required to pay a fee in order to play at a
To
reserved
reserve.
time.
In order to
Right.
reserve.
And the city of Newton has tried this issue as to whether it went for maintenance, whether it went for sodding the grass, or whether it went for watering or lighting or whatever. And in its own case, Hunt versus City of Newton, the court decided that it didn't care what the money went for. You don't have to, as Your Honor said previously, follow the money. The money was required to be paid, period. And the comparable cases are the Town of Orange, Hunt, Dedeus. Summary judgment was denied in all of them. One of them was a fee for roller skating. A boy was taking a shower after participating in a basketball league. One of them was a $2 fee to park in the parking lot to attend an event. Summary judgment was denied in all of them, and in fact, the court in 2008 in the Town of Orange case that said, and I quote, "The defendant has cited no case, and I can find none, where the owner was immune from liability under the recreational use statute when a fee was paid." It doesn't matter what the money is for. So you look to the statute, you look to a title, you look to the language. There is no immunity from suit. And looking at the City of Newton's own brief, it agrees with this categorization, where it claims on page 8, the statute conferring immunity from liability actually has the effect of immunity from suit only under certain conditions: the lack of willful wanton misconduct and the lack of a fee. In this case, a fee was paid, and there is a motion to amend the complaint to bring claims for wanton willful misconduct, which has been stayed in Superior Court pending the outcome from Your Honors. This land was adjacent to a toxic waste site. Notice was given to the City of Newton 2 decades before this accident, because the City of Newton was in a butter and its trees were overhanging onto the property. There was a limited use exclusion in effect, and the City of Newton ignored the toxic waste site and the effect that it would have on the trees and the people that it took money from to play on those fields for 2 decades. That's willful, wanton, and reckless misconduct, and the plaintiff will be able to show that. So it is our contention that both prongs of the test have been met. A fee was paid. Mr. Marcus wouldn't have been there had he not paid money. And it's ludicrous to think in any municipality that he would have had to pay the money directly to the City of Newton. You can just imagine the chaos that that would create at the city clerk's office if every kid who wanted to play soccer had to go there with his $5 to the clerks, and not to mention the parental uproar at having to drive their children there and stand in line. If every person that wanted to play basketball had to go to the city clerk's office, if every person who wants to play softball has to go to the city clerk's office.
Well, how do you distinguish those cases in which we have said, or it has been said, that this does relate to people who actually pay the fees, not to others who may be spectators at paid
Right.
events?
In those cases, if the spectators do not pay, there is no immunity. They have no suit.
Well, let's say the league reserved the field and that included the stands. All right? So loved ones of the players came and sat in the stands.
That's correct.
So how would they line up here?
They're out of luck.
They're out of luck.
They have not paid. Mr. Marcus was not sitting in the stands. He paid. He was a player waiting for his turn at bat, sitting under a rotten tree that he had the misfortune to have fall on him while he was waiting for his turn at bat. And the roots of the tree were in a toxic waste site that the city of Newton knew about for 2 decades.
Well, I'm not sure I understood what you said in response to Justice Cordy's question about the spectator in the stands. If the spectator in the stands does not pay a fee to enter and just happens to sit and watch a team who has paid play softball, does the non-paying spectator in the stands collapse? Does the non-paying spectator have a cause of action against the city?
It does not, unless there is a third party who may have erected the stands or may have maintained the stands or in some way had responsibility for the stands. There is a case where somebody was watching a child ice skate, and that person was injured, and there was no liability. The ice skater who paid to belong to the ice skating team and the team who paid for the rink could have had a cause of action, but the grandma who came to watch had no cause of action. And in any event, the doctrine of present execution wouldn't apply in this case even if the fee issue was not an issue. The purpose of the doctrine is to protect against the burden of unnecessary litigation. In this case, the complaint was filed in July of 2009. There was no motion to dismiss filed by the city. A first amended complaint was filed to add individuals, Mr. Hill and Mr. Cohen. No motion to dismiss was filed by the city of Newton. And in fact, the city responded and propounded written discovery and noticed and participated in depositions for almost a year. So they had the burden of the litigation, and they undertook it. They waived the doctrine of present.
Do you have a case or anything that, I mean, I don't know where we've ever said that you have to do it at a motion to dismiss stage. Have you got a case that says so?
No, I don't, Your Honor. However, the purpose of the doctrine of present execution is that so a party may have immediate appellate relief so that they do not have to undergo lengthy litigation. And in this case, the city of Newton, in effect, waived it by, in effect, participating in lengthy litigation. And it would seem that at this point, the doctrine would be moot. They've already done what they were supposed to be protected against, and at this juncture,
Well, they haven't gone through trial.
no, only because the Superior Court proceedings have been stayed. There's been 6
Right, but I mean,
motions.
that's what they would be, you know, that would be the piece of litigation that they would still be able to avoid, which is not an insignificant piece of part of the litigation process.
That's true.
Yeah.
That's true.
Now, do we apply the present execution doctrine to qualified immunity?
I don't believe so. It's absolute immunity, and there is no absolute immunity in this case. The city of Newton is in the same position as any of the other 5 defendants, all of which filed for summary judgment in this case, and all of which have lost, and all of which are patiently sitting on the sidelines waiting for trial and a chance to appeal at the end of the trial. None of them are here. None of them have this right available to them, nor would they, and nor should the city of Newton, because a fee was paid.
You know, this is just changing topics just a slight bit. Did you say, though, that there was in the record, because I haven't been able to find it, the permitting fee application or the document that is a permit?
It was testified to by the plaintiff in his deposition.
It was testimony, not the
Yes.
document itself?
Yes, and I
Okay.
believe the plaintiff's deposition testimony is part of the appendix.
Yes, okay. I was looking for the
Right.
permit
He was
itself.
questioned quite lengthily
Is there a
about,
physical document, by the way?
about the requirement for the permit.
Yeah.
There is a document. I don't believe it's part of the appendix,
Okay.
but the manager of the Jewish Co-ed Softball League did file a statement saying that he used the money to apply for the city of Newton. And I see I'm running low on time. Are there any other questions that you would like me to address? If not, thank you. I will rest on my brief.
All right,
Thank
thank you
you.
very much.